On that note, there was a recent case out of the 4th District, Division 3, that dealt with arbitration. I thought maybe we talk about it. It's Brown versus TGS Management Co. We'll put the all links to the cases will be in the show notes. The 4-3 there reversed an arbitration award for an employer defendant. The court relied on, quote, the substantial body of case law holding arbitrators exceed their powers by issuing an award that violates a party's unwaivable statutory rights or that contravenes an explicit legislative expression of public policy, end quote. This was actually a case from last year, and I wrote about it then. But the case was the employee was able to reverse an arbitration award for the defense on the ground that that there were questions of public policy there, and which is one of the exceptions. But I was surprised to find this exception applied here. And the court reasoned that there was a de facto non-compete that could not survive under Business and Professions Code section 16600. The court pointed to a broad confidentiality clause, which even swept in information unrelated to the business of the employer and the employee, and it swept in information predating the employee's employment. And I wondered if the Brown case might presage more cases where the Court of Appeal might make use of that public policy exceptions to drag arbitration awards under the ambit of judicial appellate review.
So we've recently had we've been involved in a few cases that have had this issue, two of which were in the context of illegality. So either the part or the whole contract had illegal provisions. And we have argued exactly this, public policy, illegality. And in one of the cases, we got a no chance, argue something else. The other two are still pending. And so I do think that this is a big area that I'm hoping will become more used, but at least in our experience, and I'm very interested to hear what you guys have been seeing, arbitration agreements awards are so routinely affirmed that we've really had a hard time, even when there's illegality involved with a contract. Have you guys seen any luck with the public policy arguments?
I can't say that I've ever attempted such an argument, but I got to say, I turned down clients seeking to appeal arbitration awards almost more frequently than clients seeking to file a writ. That's how I view the stats, because I feel like I'm just taking money, and it's such an uphill battle. How about you, Tim?
No, the same. I've been looking. I haven't seen other cases following the Brown case, but that's why I asked. Maybe this is a case that I don't remember if it was. I think it was a published case, so I would cite the Brown case and suggest that there's a trend going that direction, and hopefully, get a court of appeal to bite if you can find some good public policy angles to it.
Yeah, there's the illegality part is the hook. I totally agree with you, Jeff, about not taking arbitration cases. We too are very, very leery of doing that. And really for us, these were some really extreme issues where we would turn away 9 out of 10, but illegality is almost like sometimes they treat it differently than the public policy argument, but we're trying to find a way to connect the two and make it doubly important for the court not to affirm, because then it's making the court complicit in affirming an illegal contract and ordering it enforced. And so we're hoping it will percolate, like Tim, I think you're suggesting, and that maybe at some point the courts will get more interested in this.
Tim, I found the most interesting thing about that case, because I wasn't aware of it before, was a nerdy appellate point. Let's get down in the weeds here. That arbitration transcripts that were not put in front of the superior court were nonetheless allowed to be put in front of the Court of Appeal via request for judicial notice and relied on by the Court of Appeal. Wow, I found that kind of mind-blowing.
I didn't notice that part
Me
of the
too.
case. No, that is very interesting and surprising.
Yeah, it's an interesting point there.
I would think that the appellate record would be defined as whatever got put in front of the superior court in the petition to confirm the award.
Well, let me ask you a hypothetical, Tim. what if the appellant were arguing some sort of problem with the process of getting from the end of arbitration testimony to the point of an arbitration award? And, there's usually some back and forth and briefing and that kind of things. And whatever the documents were exchanged by the parties and submitted to the AAA didn't quite make it into the Superior Court record. And then up on appeal, the loser's claiming there was some sort of impropriety with the rendition of the final arbitration award. Aren't documents that were put before the JAMS or AAA to get to the point of the arbitration award relevant to the Court of Appeals inquiry?
I think they are.
Yeah.
Well,
I was interested to read that part of that case. Thanks for pointing out.
No, I think that that's a really important issue. That's one of the issues on reviewing illegality, is that it is reviewed de novo by the trial court, and there's some differing law on whether the Court of Appeal, obviously they review any legal issues de novo, but whether the factual issues are reviewed de novo by the Court of Appeal as well, which we know is unheard of.
Yeah.
But I think you're right. Those are important issues.